Speaker.
David Bennett.
Thank you, Mr Speaker, and it gives me great pleasure to rise in regard to the Judicature Modernisation Bill second reading, and I'd like to thank Phil Goff for the most passionate speech in regard to this bill. I don't know how anyone could get up there and shout over a bill of this length, but you managed to do it, and totally offline, but that's all part of it. Enthusiasm, that's what we like to see from the Labor Party, but this is a very substantial bill that all members of this Parliament have referred to its scope and the size and the impact it will have. And it doesn't give it justice to do a 10-minute speech on it, really, and even members of this Parliament won't be able to do that. So to cut it down to something that is probably more interesting than to go through the whole bill, as everybody would like, no doubt, for us to do. It's important, as members have focused on our judicature system and especially our court system, and the ability for New Zealanders to have good representation, to have fair representation, to actually have a system that is fair and open, and the ability to have faith in the rule of law in our country. And that is a defining thing that makes our country one of the great countries of the world, and one which we can have a parliament like this that is successful and enables people to share their views in an open and constructive way. It enables us to have a system where if people feel there are disputes and they feel that they haven't been treated properly, they have a fair and open process which they can go through to rectify that situation. It enables New Zealanders to have comfort that if they ever do get in a position that they are on the wrong side of the law, that they will actually have a genuine, open and independent process that will enable them to have the full rights that you would expect in such situations. We need to contrast that with many other countries around the world that don't have such open and fair systems. And I think New Zealanders are very proud of what the system enables us to do as a country, but at the same time, a failure to have a strong judiciary, a failure to have a strong police force, a failure to have an independent judiciary and a failure to have an independent police force can lead to corruption. It can lead to the inability of a country to grow and prosper, and ultimately can dictate that there is less democracy in the actual country. And that is something that all people in the world, regardless of their state, want, and that is a fair deal and to have the right to be heard and to make their views known. This bill, as members have said, is divided into a number of parts, and those parts cover off some of the major parts of our legal system. So although it is a substantial bill in size and scope at this stage, it actually is a reflection of many bills and many parts of our legal system that in themselves are quite substantial anyway. When we look at some of the main parts of the bill, the part one is in regard to the senior courts, and that replaces the Supreme Court Act and the Judicature Act. So it is it improves the transparency and flexibility of senior courts and provides for the establishment of a panel of judges. So that's part one that relates to senior courts. Part two relates to the district court and constitutes district courts as a unitary court rather than the many separate district courts that you have as we have now throughout the New Zealand. And that is similarly done with the family court, the youth court and the disputes tribunal. So effectively, when you go to one court, it could be the district court in Te Awamutu or the district court in Whakatane. It is all part of the district court rather than each individual court. And that is something which I think New Zealanders would have probably assumed already, but now actually see in reality. Part three looks at the judicial review procedure, and that sets up a standalone statute that continues the process and procedure for judicial review applications. So many people will be aware that judicial review is one of the the backup abilities of constituents, and in the case that they feel that the justice system has let them down. And judicial review is often used as a form of perhaps opening the ambit of what the justice system may have considered to enable those involved in those cases to be fully reflected in their judgment. Part 4 is the interest on money claims, and that was covered off very nicely by John O'Naylor in his speech, and he went through that and discussed the importance of that there and the interest that would be charged in such situations. Part 5, electronic courts and tribunals. Well, that's part of the growth you're seeing in the technology that will be used in any government department, but especially our court system needs to make sure that it has the best technology and the ability to use that technology. And in question time today we heard about that, how that can assist in the process of in ensuring fairness of trial, but also in ensuring saving of money through the system. Part 6, amendments to other enactments, covers off a variety of court-related changes to existing acts. So the legislation has a series of parts to it, and to do it justice is really quite difficult in this situation. But the context of it for all New Zealanders to understand is really that we have an excellent legal system in this country. It underpins our ability to have democracy. It underpins our ability to be treated in fairness and equity should something go wrong, or in time of dispute with another person or corporate. The strength of that legal system is built upon rules that have been developed over many years, and those rules will continue to develop. And they will require and dictate that you will have large pieces of legislation like this. But this legislation will be broken down into those series of parts, which are essentially laws that you will find around each of those areas, such as the senior courts, the district court, and judicial review procedure, and interest on money claims and electronic tribunals. So effectively we are dealing with something that is really a summary and also a proactive attempt to devise the best judicial system that we can in our country. And it's very pleasing to see that the parties in this House, especially the Labour Party and the Green Party, are supportive of this bill. It's one of those pieces of legislation that all New Zealanders can be proud of, in the sense that the parties of this Parliament come together and see its practical implications. It's not a policy issue. It is something that practically makes a better difference to the way that our systems are run, and therefore is something that would encourage people to have faith in our judiciary and our legal system. So, Mr. Speaker, this is a strong bill, which is a substantial bill as well, and will achieve its purpose. And we appreciate the support that other political parties have played in this House. And I think, as mentioned before, a thank you needs to go out to all those involved in writing the legislation, to the officials that have been involved for their great work in this. Thank you, Mr. Speaker.